Errol Gerson, can you hear me?
I can hear you just fine.
All right, so Errol, I'm just going to do a little bit of an introduction, and then I'm going to go ahead and hand the mic over to you, and we'll get things going. All right?
Sounds good to me.
Great. Okay, thank you to everybody for signing on. I know that a lot of people are still popping up in here. We do have a little poll going on the side just to get a little sense of who's showing up, what part of California or not California you're from, and what type of work you've been doing. As I said, I'm Patrick Fredrickson. I'm Vice President of the AIGA Los Angeles chapter. We've got a lot of our Los Angeles board members here on the line. Amanda Hovest, our president, is on the line. Former President Jason Adam, we just saw, is on the line, which is great. But most importantly, you know, we have a ton of people here on the line who just have a lot of questions. And that is the reason for us trying to put together this Q&A session. So we're doing this as a meeting. Not as a full-on webinar. We are recording the information so that we can share it later on. Really this came about because Amanda Hovest, our friend Don from up in San Francisco, many of our board members were continuing to get questions about AB5 and the gig economy law, wondering how it's going to be affecting designers and the design industry. And that created a lot of conversation, which got us just wanting to know some more information. Here in Los Angeles, we're lucky to have Errol Gerson as one of our senior advisory board members. And he is a trove of knowledge. Anybody who follows The Future, his interviews on The Future are some of the highest followed productions on that cast, knows a ton of business, has been around and supporting the creative community for ages, and you know, a good friend and champion for the chapter and creatives all over the place. Most importantly, I want to share this and need to share this. Errol is not an attorney. Anything that is being shared today is by no means legal advice. This is information being shared by a man who has 40+ years of experience as an accountant, working with the creative industry, personal understanding of some of the implications and uses of BORELLO. But he is not speaking from legal advice. He is sharing information from what he has done and used as an accountant and worked with in Sacramento. He is also not speaking on behalf of AIGA or AIGA Los Angeles. He is simply a colleague who is willing to share the information that he has and begin the dialogue and discussion. He will. What I ask you to do is, if you have questions, please hit me up on chat or begin posting your questions on chat. I will be taking them down, and at various times throughout this conversation, we'll be raising some of those questions to Errol. So with that, Errol, if you want to take over of the screen, then we can get things going.
Great. So Patrick, quick question.
Yes, sir.
Is it time for me to click share?
Oh, yes. Yes, time for you to hit share. And Errol, I also want to let you know, it looks like a majority of people who are coming in here are on the freelance solopreneur side. We've got about 20% of respondents own an agency or work within an agency. We've got a majority of people are here in Southern California, like LA, OC type of area. And we've got creatives from all over the place. We have creatives who are in the design field. We have creatives who are musicians. We have creatives who are writers. So there's a lot of different creatives who are popping in to find out some information.
Patrick, when I try to click share, it says I can't because somebody else is already sharing.
Well, let me fix that for you. I'm going to, we had this working the other day, didn't we? That's not going to be good.
The alternative is I'm happy for you to run the program and I will just speak, but.
There, okay, I paused my share. See if you can get yours in now.
No. Yes, I can.
There you go.
Okay, so now there is your name, but the program is not running. Let's try that. Okay, now I should be able to put it into projection mode, which I think it is. So
there you go.
Can everybody see?
You're looking good, Errol.
Okay, well, Patrick has already run the disclaimer, so I appreciate it. It is very important, my friends, for those of you who are in line, to understand that I am not giving you legal information, but simply my opinion as somebody who has been around this industry for almost 45 years. Patrick, when will they be able to submit questions? Do you want to talk about that?
Yes, for anybody who's submitting questions, share the questions in the chat. You can share them to everybody, or you can post them directly to me, and I will be following along and at a couple of slides, at a couple of the break slides, then we'll bring the questions up to people.
Okay. So it's a very interesting question that we're going to ask, and that is, who is an independent contractor? Now, this is not a new subject, my friends. This subject's been around for probably the last 35, 40 years. However, in all good conscience, the state of California Supreme Court enacted the Dynamex case, and that became known as AB5. Assembly Bill number 5 basically reinforces a case that happened back in March of 1987. And we'll go into this later on, but that case was called the BORELLO case. And it's been the law of the land for a very long time. All that the Dynamex case did was to make BORELLO much stronger and also link BORELLO to the Internal Revenue's A.B.C. test. And I'm going to go into all of these, but I'm going to try to keep it at a level where we can all easily understand this, because, my friends, if you saw the amount of reading material I have just for tonight, it's probably 3 inches thick. So I'm going to try as best as I can to use the KISS method, which is to keep it simple, stupid. So we're going to look at BORELLO, we're going to look at the Dynamex case, and we're also going to look at something that's been around a long time called the A.B.C. test, and then, of course, how all of this fits in to Assembly Bill 5 for the state of California. Now, at the outset, let me say that AB5 is going to be tested. For example, both Uber and Lyft have raised millions of dollars, literally millions of dollars, because they are the ones who stand to lose the most. If every single driver for Lyft and for any rideshare or any companies who deliver food, any of the gig industries, they are going to be dramatically affected. And the cost to them could be in the billions. Therefore, I'm telling you that in my professional opinion, there are going to be significant tests to AB5. So the fact that the statute is on the books is one thing, but there is no decided case law yet. With that in mind, let's take a look. So all of this began back in 1989 when a farming company by the name of S.G. BORELLO and Sons was brought before the California Supreme Court by the Department of Industrial Relations for the following reasons. The question was, whether or not agricultural workers picking cucumbers under what's called a share farmer agreement were independent contractors who were exempt from workers' comp coverage. This had nothing to do with whether or not they were independent contractors. It had to do with whether or not they should be covered by workers' comp, because when these people were hurt in the field, S.G. BORELLO and Sons refused to take care of them. So they brought suit, and the court found that in point of fact, as a matter of law, share farmers are employees and are entitled to compensation coverage and a number of other things. So again, from 1989, the state of California began looking very, very carefully at a myriad of companies who hired what were called independent contractors. Now, the question is, who has to pass this BORELLO test? And the answer is fascinating. All people, all workers, except for real estate people, must pass the BORELLO test to be classified as an independent contractor. Now, in my 45 plus years, I have represented literally dozens and dozens of large graphic design firms all over the country, and probably hundreds, if not thousands, of independent contractors who were graphic designers, photographers, illustrators, people involved in the graphic arts and the visual arts. I can tell you that in those days, the vast majority of the small graphic design firms and medium firms that I represented were all in violation of BORELLO. The good news is they never got caught, because they had people working for them who were clearly employees. So now let's take a little closer look at this. What I want you to understand is that this BORELLO case is according to the laws of the state of California. However, the Internal Revenue Service has had on the books for over 20 years the A.B.C. test, but interestingly enough, it's not as strict as BORELLO, as you will see later on. So what I want you first now to understand is, what are the requirements of the BORELLO test? Well, here's the first and most important overriding question. Does the hiring company have, and here's the word, control, or the right to control the worker? When we say control, what are we talking about? One, we're talking about with regard to the work that the worker is doing for the hiring firm, and two, the manner and the means in which it's performed. So this is going to bring up all kinds of questions, and this is the time for you to start writing them down and passing them on to Patrick. However, once I go through the specifics, and there are 11 of them in BORELLO, it will become a little bit more clear to you. But with this in mind, and remembering this word control, let's take a closer look. Here are the 11 elements of BORELLO. Number one, whether the person performing the work as an independent contractor is engaged in an occupation or a business that is distinct from that of the hiring company. Let me give you an example. Errol Gerson is a graphic designer, and I get hired by the Upside Down graphic design company of Santa Monica, California. Arguably, we're in the same business. Under BORELLO, under the interpretation of BORELLO, I'm going to be an employee at this point, because the work I do and the work that the company does are in fact one and the same. Now, I noticed that there are a number of musicians online tonight. And the good news for you is that in my 40-odd years, more than half of my clients were in the music business. So I represented bands, I represented composers, I represented studios. So for you, this is going to be a big issue. Presuming that you are running a studio and you hire a songwriter for one day to write a song. Since the songwriter might be in the same business as you, he or she may be an employee. But because you're a studio, quote unquote, and this person is a composer, you would be exempt from item number one. So what do you learn from this? The way you define the people who are going to work for you as independent contractors is of paramount importance. So you have to think about, how am I going to define them? Let's look at number two. Whether the work that the independent contractor is going to do is part of the hiring company's regular business. That's very much linked to one, but very, very importantly, it's saying if the work that they are doing for you is a part of the hiring company's regular business, this person is an employee. So once again, you're going to have to be very careful with the way you define them. Number three is very interesting. It's going to ask a very important question. Whether or not the company or the worker supplies the equipment, the tools, and the place for the person to do the work. So, example, Errol Gerson is a graphic designer. I'm going to work for the Upside Down graphic design company of Santa Monica, and they decide I'm going to use their computer, I'm going to use their printers, I'm going to sit at a desk provided by them, and I'm going to be in their office doing all of the work. I can guarantee you, soup to nuts, California would declare you an employee. Unless you have the right as the independent contractor to work at your own place, can be your own home, unless you have other clients, unless you use your own computers, your own printers, your own supplies, and you set your own hours, you're going to be declared an employee. And this one, number three, of all the audits I've ever had, I've always lost because of number three. Number four, the worker's financial investment in the equipment or the materials required to do the work. So, you know, if you just graduated from Cal State Northridge and you're working out of an apartment which you share with a friend, you have no office, and you're borrowing a computer from the company who's hiring you, you're going to have a problem. Because the state of California is going to say that in point of fact, you're not in business. All you are is an employee of the company because you have no financial investment in your own business. So once again, this is one of the tougher tests of BORELLO. Comes number five, the skill required. There's nowhere in the code that says you have to have a degree from Cal State Long Beach, you have to have a degree from Cal Institute of the Arts, you have to have a degree from Art Center, but it does say that you must have a minimal skill. Well, what's minimal skill? To know what a typeface is? To know what a color wheel is? And the answer is, we don't know. And it is going to take a case to test this, and I can guarantee you there will be tests before 5 become steeped in case law. Let's go to number 6. Number 6 talks about the kind of occupation with reference to whether in the locality the work is usually done or under the company's direction or by a specialist or supervision. So let me clear up this very confusing language. If as a graphic designer, the Upside Down company calls me in, sits me down, trains me in how they work, tells me what to do, when to do it, and when to come in, congratulations, you just hired me as an employee, and there's nothing you can do about it. So this is one, number 6 is one you're going to have to pay very, very careful attention to. Number 7, the worker's opportunity for profit or loss depending on his or her managerial skill. Potential for profit does not include bonuses. So, what are they talking about here? Yeah, they're talking about whether or not this independent contractor has been in business long enough to acquire business acumen. Have they taken some business courses? Have they taken some of the courses that are available online, through lynda.com, through the future, through any online university? Do they have any requisite financial skills to manage their business? And if the answer is no, BORELLO will contend that you potentially may be an employee as well. Number 8, how long the services will be performed. My friends, if you're going to hire Errol Gerson for the next 8 months to work on this project, I can guarantee you right now, the Franchise Tax Board would declare me an employee. Once again, how long has not been tested. There's an old test that is 19 hours a week, but again, that's never faced a case either before the California Supreme Court or the United States Supreme Court. So how long my services are needed is going to have to be tested. But since I just had an audit less than a month ago, because the independent contractor was there for 5 months, the Employment Development Department declared her to be an employee, and the case, that was the end of the case. My client has decided not to appeal. Number 9, the degree of permanence of the working relationship. Well, you can see that number 8 and number 9 are very closely linked, because the longer the services are being performed in number 8, the greater the degree of permanence in the working relationship. My friends, I've represented graphic design firms who had independent contractors there for periods of up to 3 and 4 years. They're just lucky they weren't caught, because had we been audited by the Employment Development Department from the state of California, we would surely have lost. Had we been audited by the Internal Revenue Service, we would surely have lost. Now, the fact is, all of you independent contractors know that if you earn $600 or more at the end of the year, you get something called a 1099. Guess what? Those 1099s are all done electronically, and the Internal Revenue shares them with the state of California. So all of a sudden, the state of California can take a look at the A.B.C. Upside Down Company and find that they've been kicking out 1099s to the same people for 5 and 6 years. Well, congratulations. You're going to get audited, and when you do, give me a call. I'll be happy to help you. Number 10. And this is an interesting one. This is the payment method. Question is, are you paid by time, by the hour, or by the job? Now, once again, this hasn't been tested, but in the audits that I've done, the state of California prefers that the independent contractor not be paid by the hour, that they prefer that the independent contractor submit a bid for the job, which can be modified through a change order, but they dislike it when independent contractors paid by the hour because it feels like an employee. And lastly, number 11, whether the parties believe they are creating an employer-employee relationship. Now, most companies whom I consult with, I mandate that they have a contract prepared by an attorney called an independent contractor agreement. And I've had a hand in putting many of these together, so they are very strict. And if my client gets the independent contractor to sign it, there is a greater probability that they would survive an audit. But if you do not have any agreement The Internal Revenue Service will mandate that they are an employee and you have to prove differently. The other thing that is very important if you're a hiring company is for you to have an employee manual. And in the employee manual, you differentiate between who is an employee and who is an independent contractor. And the reason you have to do this is all about income tax. And I'm going to talk about that a little bit later on. But here are 11 items of BORELLO. And I thought at this point, there may be some questions that we can talk about. And so, Patrick, if you have any that people have submitted, I'm more than happy, and I can go back to the critical factors without much trouble at all. Let me just get back a couple of screens. Okay, so Patrick, are there any questions on BORELLO? And if there aren't, I'd be surprised.
Yes, Errol, there's a number of questions coming in. I'm just going to run through some of the ones that have been popping up. One, kind of one of the first ones, understanding that what we're not providing today is legal advice. For people who are running, for people who are trying to set up their own companies, where would be the best place for them to go to get good advice on how this might affect their business models?
So the answer is twofold. The first is to go to your CPA.
Okay.
Because your CPA is well steeped in AB5. And forgive me if they aren't, run as fast as you can out of that office. The other place to go is to an attorney. However, if you go to an attorney, you are going to potentially be looking at spending a lot of money. And I think you are being a bull in a china shop, because I don't think it's necessary. I think that if you go to your accountant, to your financial advisor, and ask a simple question, are you familiar with AB5? Are you familiar with BORELLO and the A.B.C test? And he or she says yes, then follow their advice and you will have no problem.
Sounds good. All right, so go to your CPA, ask them for their advice, ask them if they're familiar with them, save the attorneys for when you have money that you want to spend. Another question that's coming in, and what actually this might trump some of these. For the BORELLO items, how many of them have to be met? Is it like a majority of them? Is it all of them? Is it one of them? How exactly does that test?
So your middle answer said all, and it's all.
It's all of them.
It's all of them.
Okay.
That's the problem. It's all of them. And so you can't say, I passed 1, 3, and 7, so life's good. No, not true. You got to pass all 11.
Okay.
That is why I keep saying, the way in which you define this person that you are hiring is going to be very, very important.
So that, I think, leads right into another question that came up. There's somebody here on the line who, with their agency, they have a number of consultants, the consultants then get placed with clients specific to the client's needs and the consultant's specialty. Now, sometimes those are, they're working with the clients for 5 hours a week. Sometimes they're doing 5 hours a month. Is that something that they need to be concerned about, about these consultants being looked at as employees?
Okay. So the first thing you have to do, we have to define a consultant. A consultant is a person who knows how to make love 40 ways, but doesn't have a girlfriend. But that's okay. That's okay. Errol Gerson runs a large advertising agency. And I have 5 people who are, quote, in my company, and they act as consultants. Now the question is, number one, you say this consultant, you hire them out for 5 hours. So let me ask who's ever asking this question, the following sets of questions. Number one, have you ever trained this consultant in what they have to do? What's the answer?
I'm hoping no.
Because if the answer is yes, congratulations, you got an employee. Okay. Number two, if you tell this consultant when they have to go to the client, how many hours they have to do, and what they have to do, congratulations, you just hired an employee.
Right, that's the control factor, right? You're controlling when they, okay. Okay.
So I've heard this term consultant used because people think it's a clever way to get around saying an independent contractor. No, it's just a wolf in sheep's clothing. That's all. There's no difference. If you tell them what to do, when to do it, you give them a computer, you give them a desk in your office, and congratulations, you just hired an employee.
Now, we're not controlling what they, like when they're working, but we are, defining the level of expectations for deliverables, right? Just like we would, hiring a firm, an agency, anything like that. Is that?
Congratulations, you just use the word control.
Okay.
The Internal Revenue Service defines an employee as an individual over whom you exercise control, beginning, middle, and end. And by the way, we're going to get there in some later slides.
Okay, all right.
To the person who's asking this question, I would be very, very careful. And by the way, one of the reasons why companies like to keep them on as consultants is simple, so that when there isn't any work for them, they don't have to pay them. Well, Uber and Lyft, thought the same thing. And I can tell you that it's going to cost Uber and Lyft an extra 30%. Can you imagine what the cost of a ride is going to be if and when AB5 goes to the Supreme Court, which it will?
Right.
Guess what? Same is true for any firm, any graphic design firm who's found guilty of having an independent contractor or many who are really employees. The punitive result, and I'll go through it later on, but you can calculate it's going to cost you an extra 30%. 30.
Okay.
If you can't afford to keep this individual as an employee for enough hours a month so that both he, she, and you are both doing well, then, be careful. Either do the work yourself or follow BORELLO.
Errol?
Other questions?
Yeah, so I think that this gets to it a little bit more, but one of the things that now if your consultant, has you're not the only person they're working for.
Good. That's very good. That's very helpful.
Later slides, doesn't it? Okay.
It's a difference, but let's go back to the original question.
Mm-hmm.
Are they under your control or not? Do you find a client for them? Do you tell them when to go there? Do you tell them what to do? Again, it's all spelled out in BORELLO 1 through 11. Okay. All you got to do is answer the questions. By the way, I'm not suggesting everybody in California and the United States is going to get audited. There are not enough auditors. So it's going to be a relatively small number. And I think they're going to go after the larger graphic design firms and the larger companies who kick out a lot of 1099s. People who've got 3 or 4 people, honestly, the chances of you being audited are very small.
Right. Okay. So now that we're getting into some questions, there's a lot of other questions coming up. I'm going to ask two more, and then we'll go into the next set of slides and see if that clears some things up. All right, and I'm going to keep track of some of these that are coming up. So Errol, if somebody's an independent contractor, is there any advantage to them being an independent contractor as an S Corp versus a C Corp?
It's a complex question, so I'm gonna give a short answer.
Okay.
I would much rather you considered being an LLC or an S Corp rather than a C Corp for the following reasons. C Corps are much more expensive to form. They are much more rigorous and onerous with regard to the amount of paperwork. And frankly, unless your company is getting into the millions, you shouldn't even be thinking about it.
Okay.
Now, having said that, acting as a sole proprietorship, the only difference between a sole proprietorship and an LLC or a subchapter S is that under both LLC and sub S, you get limited legal liability. As a sole proprietor, you have unlimited legal liability. That's the real difference. Now, there are some other benefits in an LLC and other benefits in an S Corp, but I would surely stay away from C Corp unless you're planning on taking your company public one day. It's really onerous.
Yeah, this is getting into the details of that is a conversation for a future webinar. So I know that I know you've spoken to us about that in the past. All right, one last question before we go into other things. Unpaid versus paid internships, and how is that going to be impacting internships?
Okay, so let me define an unpaid internship.
Define it nicely. Define it kindly.
I shouldn't use any expletives. Okay.
Yes.
Okay. Slave labor.
Yeah.
And they're going to get hit. As many of you know, I teach at Art Center. I've been there 49 years. Art Center does not permit unpaid internships, not ever. Every single internship must have a stipend, and no, they will not be subject to independent contractor status. They will be independent contractors because they will meet BORELLO. Now, there are some conditions where an intern who comes in and is trained and told what to do and given a desk and given a computer may well be in violation of BORELLO, but this again has to be tested because colleges and universities, if they have to now go to a company and say, well, we want you to hire these young people, in internships because they learn a lot, but I'm terribly sorry, you're going to have to make them employees. That is going to become a huge impediment to hiring them. So I am very eager, and I've been speaking with Art Center about this, for us to get an early test by applying for a private letter ruling to the Employment Development Department, because it can be very onerous.
Sounds good. Errol, I'm gonna let you go into your next set of slides while I try to catch up on some of the chat that's been going on over here, and we'll pick up on some of the next questions.
So there is a critical factor. No single factor in BORELLO is determinative. No single factor. But the one that is the following: whether the individual's work is the service or product that is the company's primary business. The court has already said this will be given the most weight. So a graphic designer who goes to work for a graphic design firm will more than likely be in violation of this single factor test of BORELLO. So for graphic design firms, this presents a serious problem because all of the graphic designers that I've represented, that's everybody from Robert Miles Runyon and Rick Runyon and Hinshuke, all the guys from the past. They hired graphic designers all the time as independent contractors. And under the new law, this is going to be very, very difficult to do because the courts have said the single factor in BORELLO that has the most weight will be whether the individual's work is the service or product that is the company's primary business. Now, what if a graphic designer did a independent contractor stint at, say, Media Monks? Is Media Monks an ad agency? Are they a digital agency? Are they the same work as a graphic designer? Once again, the way you define the individual who's coming to do the work is going to be very, very important if you're audited. And you're going to have to make copious notes and keep a file of paper on this individual so that when and if you have an audit, you have something to put in front of the employment development department. And they're tough, okay? They're tough cookies. So that's very important for you to remember, this critical factor. Now, in addition to BORELLO's 11 points, there is a further requirement that says you have to also comply with 7 professional services requirements. But there's wonderful news. Graphic designers are exempt. So you are exempt from what's called the PSR, the professional services requirement. And because you're exempt, I'm not even going to go into it. Good news, you do not have to be in compliance with the PSR. So everybody clear about that. If you're a graphic designer, you do not have to meet the requirements of professional services requirement. Now we come to the really bull in the room. And it really is the big bull in the china shop. And that is the A.B.C. test of the Internal Revenue Service. Oh dear, this is being recorded. I could be in big trouble. Mr. Trump might come after me. Now, in the Dynamics case, this is the one that just resulted in AB5, the court also found that a worker, and please watch this language, could only be an independent contractor, only be, if each of these 4 factors is met. So in addition to the 11 BORELLO, watch these 4, because the IRS says, absent these, they're automatically employed. Let's look at number 1. That the worker is free, here's the word, from the control and direction of the hiring entity in connection with the performance of the work, both under the contract and the work itself. See the word? See, there it is. The control and direction of the hiring entity. So the auditor will come in and ask you a very, very simple question. And they'll say it in a very naive way. Excuse me, Mr. Gerson, but Mr. Fredrickson, did you ever give him any training? Oh yeah, we trained. The minute you said, oh yeah, the auditor took out a book and went, employee. So you have to be very, very, very careful. Now, this word control is actually defined by the IRS, and it's defined by 3 factors. 1, the behavioral factor. In other words, what is your relationship there? If you've been there for 8 months, 9 months, do you know all the people by first name? When you walk in, do they say, hi, Errol, how's everything? That's behavioral. 2, financial, how are you paid? Are you paid by the job? Or are you paid by the hour? Again, be careful, because when you're paid by the hour, sounds like you got an employee. And 3rd is the relationship. How long are you going to be there? Because normally an independent contractor is finishing a job of short duration, 3-4 weeks. When it starts getting longer than that, the Internal Revenue and the Employment Development Department and the Franchise Tax Board begin to think of themselves, we got employees here and we're not collecting the money. Because my friends, make no mistake about it. This is all about money. It's all about money. So here's test number 1 of the ABC. The work is free from control. Let's look at number 2. That the worker performs the work that is outside the usual course of the hiring entity's business. So again, what are we saying? Well, if a graphic design firm hires a graphic designer, you got a problem under number 2. Mostly this applies to Uber and Lyft because drivers, who work for Uber, they're just ordinary people who, there may be a gardener during the day, there may be a doctor who's making some side money, but they're not in the same business as Uber. This was aimed directly at those people in the gig economy, and by the way, those people who are now delivering food, because it's going to hit them as well. So test number 2, does the worker perform work that is outside the usual course of the hiring entity's business? If the answer is yes, good for you. You've passed test number 2. Test number 3 and 4. The worker is currently engaged independently in an established trade, occupation, or business of the same nature of the work being performed. So what does that mean? Errol Gerson goes to work to doing some graphic design for YouTube, perfectly fine, different business. And I am currently engaged as a graphic designer. I have 7 other clients. I've been doing it for 4 years. I have a business. I operate out of my home. Congratulations. You just passed number 3 without any trouble at all. Number 4. If you don't have a business license and you don't have a place of business and you don't have multiple clients, congratulations, you're an employee of the entity who hired you. And let me tell you, I've had probably 30, 40 IRS audits of the ABC test. I don't think I won a one. And I would warn my clients all the time. In fact, not only would I warn them, but I'd make them sign a letter that was called a get out of jail free card that said, when you get audited, don't blame me. I'm the guy who told you, be very careful. So here's the ABC test. Let's just go back. Number 1, the word control. If you remember nothing else control tonight, remember the word control. Control and direction. If you're under control and direction, congratulations, you're an employee. Number 2, if you perform work that is outside the usual course of the entity's business, Errol goes to consult for YouTube, good. It's great news. You passed the test. Number 3, that I have a graphic design business, I file a tax return, I have a city license, and I operate out of my apartment, which is perfectly legal and tax deductible. And so that's good news. That keeps me away from being an employee. And number 4, I got a license, I have multiple clients, it's all good. So Patrick, maybe at this point, if there are any questions on the ABC test, I'd be happy to answer those.
Yeah, Errol, I think that there's a couple coming in. I'm trying to navigate them a bit. One that has, I'm going to go backwards on some of these a little bit. One that came up is specific to things. There's many things that we need when we run an agency, right? We might be running a creative agency. However, within that, you've got administrative assistants, who are helping out with that agency. Now, that's a skill that may be needed to help your agency run well, but that's not necessarily the core competency of what your company does. So if you have an administrative assistant, who you're asking for, 4 to 8 hours a week, you know, worth of support, I guess, you know, questions are, do they need a business license? Should
No.
they be invoicing you? Like,
No, they're employees.
They
Employees
are.
do not need a business license. And yes, this person is employed. Administrative assistant who comes to work 5 days a week, is told what to do, use the company's computer, use the company's email, has got training. Congratulations, he or she's an employee.
Now, what about the nature of, you know, today we can have an administrative assistant who, you know, lives in another state, who lives in San Diego, who lives in a different city, but they're still helping to kind of navigate the conversations, set up meetings, you know, respond to vendor requests. You know, now that we work in, you know, more remote offices, like how is that affecting this idea of their showing up to work?
Okay. Do you control them? Do you tell them when they have to work for you, or can they just show up whenever they want? Hi, Patrick, it's Tuesday. Do you need me? You don't need me? Oh, hell, I'm not going to eat today.
Right.
This person who lives in Des Moines, Iowa, they have a business license? Do they have other clients for whom they provide virtual administrative assistant to? Once we go back to control and once we go back to training, we're in trouble.
Okay. So as soon as you set limitations on you know, when they need to be doing it or what days they need to be doing it.
Congratulations.
Okay.
Definition of the word control.
Now, when it comes to having multiple clients, do you need to have multiple clients at the same time, or can you have multiple clients throughout the year?
Throughout the year.
Okay. So just as long as your income's not coming from one, you know, sole organization.
If it's coming from one client, I can guarantee you, whoever that client is going to lose the audit and you're going to be called an employee.
Okay. Now, this came up in this thread in relation to musicians. I've heard it come up elsewhere in relations to truckers. So I'm going to try to put them together. You know, these are two sort of trades where you might be an independent contractor. You've always been considered an independent contractor. However, you're told when to arrive at the gig or when to arrive at the pickup, how long you're going to be staying there, how long it's going to be lasting. I mean, my understanding is that this law is, you know, that the trucking industry is really taking a look at what's going on here. And I would imagine that the music industry needs to be paying attention to this as well.
Yeah. So
okay.
Since I know nothing about trucks other than that they have 18 wheels, but I spent 40 years in the music business, I'm happy to talk about the music business.
Mm-hmm.
Errol Gerson is a session musician. Okay, I play guitar, and Bob Dylan has decided to make an album, and his producer, Johnny Goodears, called me and said, Errol, we'd like you to come and sit in on 2 songs for Bob. We're recording them somewhere between Monday and Wednesday, not exactly sure. Not sure how long your part will take, probably 3-4 hours. Am I an independent contractor or an employee? It is my opinion that I am an independent contractor. I bring my own guitar. I come in and perform the music. Nobody says to me, Errol, could you play a C chord? Obviously, I'm trained enough to read music. Could I be wrong? Sure, I could be wrong. But I would vehemently argue that a session musician is most assuredly going to be classified as an independent contractor. Now let's talk about sound engineer. Sound engineer is going to be on the project a month. It's going to be told when to be there. It's going to be working on a control board that is owned by the studio. I think it's strongly likely that the recording engineer may well be called an employee. Now again, as I said in the beginning, AB5 has to be tested in order to become case law. It is currently a statute. These tests are going to happen all the time. Music is most assuredly going to be one of those that is aimed at immediately. Now, fortunately, the RIAA is the Record Industry Association of America is very interested in this. And so I think that there's going to be very, very soon some articles that appear probably in Radio and Records and a lot of online music sites talking about the implications of AB5. But again, you have to go back to BORELLO and you have to go back to the A.B.C. test because they are the law of the land.
All right. I'm going to read a question to you directly. I'm going to read a question specifically to you. This is from Aaron Kaplan. I'm a composer and my assistant works both with me at times at my direction and often in his own home and at his own discretion in terms of time. He also earns equity in the end product in that when he writes music through my company, we share in the ownership of the music. I pay him hourly, and when he writes music, I give him half of the writer's share.
I think you're 100% fine. Please make sure you give him a 1099 at the end of the year. And please tell me that you do, because that's very important.
Yes.
And I believe since you have where you split the writer's royalties, and he may have his own ASCAP and your own or BMI, either way, doesn't matter. I think you're fine. Just be very, very careful when you talk about, telling him what to do or giving him direction. There's a big difference between collaboration, yes, and when you tell someone what to do. It sounds to me like you are collaborating with another artist, and I hope that that artist, this other person, has other clients and receives royalties from other songs that he or she has written. If the answer is yes, I think you're fine. My cat agrees.
Your cat agrees.
My cat just gave you the CAT scan. You see now.
Now, Errol, this next one, it gets to kind of the nature of what design is, and maybe this is what design has always been. However, the idea of what our core business is. During the first half of the year, all of my clients might be, I might be focusing directly on developing branding and strategy for a company. And so for the first half of my year, my core business is strategy and facilitation. However, the next half of the year, I pick up a ton of web work and I'm doing a lot of development. So if the nature of how we work as designers or as design agencies, like what our core business can shift from, throughout the year. How do we navigate that in terms of, who are hiring or at what stage, are they working towards our core business or not?
That's a very good question. One of my recommendations was to be careful how you describe yourself. If you use the word graphic designer, which is a generic and very amorphous term, and in fact, if you look it up on Google, you'll probably get sick. But if you are doing both, and again, when we say web, I'd rather use the word digital. If you're doing digital design as well as strategic consulting, then I'd call myself a digital brand consultant. You see, The word digital brand consultant is so far sweeping that if the auditor were to come in and ask you, you wouldn't have the faintest clue what the hell it means. So again, the more clever you can be in the way you describe yourself, the greater the chance that you can stay as an independent contractor. Now, let me say this. If the company that you work for is audited by the Franchise Tax Board or the EDD, and you are determined to be an employee, there's a whole world of tax hurt that just happened to you. Because as an independent contractor, you can write off any and every expense that is incurred as a direct or indirect result of doing or trying to do business, provided it's real, reasonable, ordinary, and necessary. So that means if you're one of my clients, I find a way to write off your cat. However, the minute you become an employee of this company, congratulations, you just lost all your deductions. And that could be a disaster for you. That is why, before you go and start doing this work with these companies, that the two of you agree that there must be a written independent contractor agreement, that you ensure that you can work at your own facility, use your own equipment, no training required. Yes, the client can tell you what the end result is expected to be. Of course, that's not an issue. But my friends, if you want to maintain this very valuable independent contractor status, which gives you enormous tax deductions, then you're going to have to play by the game. And the game currently is BORELLO and the A.B.C test of the IRS. Now let me switch gears. Let's presume I'm talking to somebody who's been, quote, an independent contractor for 3 years at a company. And they're paid by the hour, more than likely without regard to overtime, which is potentially a violation of the law. I believe you are being taken advantage of. And I believe that you are being called an independent contractor to your detriment. Because if you've been there 3 years and you're working 35, 40 hours a week and you're under their control and you have a desk and their computer, here's what you don't have. You ready? You have no coverage under workers' compensation. You have no coverage under state disability. The company doesn't provide you with vacation if they provide it for other people. The company doesn't provide you with health insurance if they provide it for other people. The company doesn't provide you with a 401k or a pension plan if they provide it for other people. So at the end of the day, with all due respect, you're getting screwed.
Well, and to be clear, those are many of the arguments that have been raised and kind of informed the development of the AB5. Correct? Is that I mean, it seems like it's been targeted a lot more towards the technology companies who seem to have a tendency to hire people as independent contractors.
Yeah, they do, and what they do is they use hiring companies. So in other words, they hire a company who hires the workers, and then they pay no benefits.
Right, right.
Don't get me started, because then the little hair I have, there'll be a little bit less by the end of the evening. I'm now talking about graphic designers, and I know many of them who've been taken advantage of for a very, very long time. And at the end of the day, it's wrong, because the company has benefited greatly. Company does not pay towards your Social Security. company doesn't pay towards your federal unemployment, towards your state unemployment, towards your employment training, your state disability, nothing. So they get to pass all those costs along to you. And what do you end up with? Well, hopefully, if you're managing your business well, you still are able to make a decent profit at the end of the year. But if you've been there 2, 3, 4 years and they violate all 11 sections of BORELLO, with all due respect, my friends, you should seriously consider having a conversation about whether or not you're an employee. Now, they may retaliate against you and say, wait a sec, if you don't like it, you can leave. As far as we're concerned, you're an independent contractor. Well, that's a decision for you and an advisor at some point. I'm not telling you what to do.
Right. On that, it doesn't. Isn't that also? There's some questions in here about independent contractors and what they can do, because much of what we've been talking about is kind of more from an agency standpoint. Now, with this, I know you've mentioned quite often that the federal, the FTB, that they can come and say, well, this person is an employee. From my understanding, these new laws also allow you, as somebody who's been classified as an independent contractor for the past 3 years, to then actually raise the question and say, no, actually, you need to treat me as an employee.
You absolutely have the right under AB5. And it is my belief that if the company were to terminate you, I'm not a lawyer, but I believe you'd have very strong grounds for wrongful termination.
So when it comes to independent contractors, people who are classified as independent contractors and feel like they should be employees, they may now have the ability to call that into question and have legal right to call that into question. However, for those who want to remain independent contractors and remain hireable under AB5, it sounds like they need to pay very close attention to these 4 facets. Are they engaging in trades that are different than, the core competency of the organization? Do they have a business license? Do they have multiple clients? Like how are independent contractors going to be able to, who want to remain that way, remain hireable versus, what we're already seeing is, job postings going out saying California, California residents need not apply.
Well, if you want to stay self-employed and you want to be an independent contractor, which is great, no problem. Make sure you comply with all 11 of BORELLO and make sure you comply with all 4 of the A.B.C. test. However, the onus of responsibility is not on you. It's going to be on the company. They're not coming after individuals. They're coming after companies. They're coming after companies that issue 20, 30, 40, 50, 1099s at the end of the year. That's who they're coming after, because they're looking for payroll tax.
Right.
Remember, a self-employed person doesn't pay payroll tax.
Yeah, without getting into that, I don't want to get into that aspect of the conversation. But I understand what you're saying there. Errol, there's a question that's coming up. And yes, Sean, there are already jobs being listed as California residents need not apply. However, I'm not sure if Errol shared this, but there's 20 other states are currently working on developing laws like AB5. The great thing about California is that we're one of the leaders in a lot of good social movements. And this is one of those social movements that all of the other states are going to wind up following in line in. So while right now they might not be hiring California contractors, in the very near future, all states are going to have the same laws. And so we can all get screwed easily.
Yeah, I have no doubt all 50 states and possibly even Puerto Rico will at some point adopt this. Because remember, my friends, this is all about money.
Errol, there's a question here that came up a couple times. And I don't understand it exactly, so I'm just going to read it. And this is from your good friend, Jason Adam. The doubling of the federal standard deduction to $12,000 and the effect that that has on solopreneurs. Because you were talking about as a solopreneur, as a freelancer, the deductions that you're able to take yourself.
Once
deduction is higher.
A self-employed person has collected all their income and their expenses, they list it on Schedule C, as in Charlie. If you subtract all of your expenses from all of your income, that is called net income. Net income is then transferred to the front page of the 1040. And again, we're going to get way into the weeds, which I don't want to do, but you will get a special 20% deduction, which is a new part of the Jobs Act. And then you will come to what is called adjusted gross income. From adjusted gross income, you get to deduct this standard deduction. Under the Jobs Act that Mr. Trump passed, the standard deduction was doubled. And so most people who used to itemize their deductions, and by the way, the only way you would do that is if you own a home and pay interest, and you pay property tax, and you have a lot of federal and state income tax taken out of your check. Well, the vast majority of Americans no longer itemize their deductions. And so doesn't impact self-employed person any differently than anybody else. It simply means the likelihood of you itemizing is zero. That's all. You don't pay more tax or less tax.
Can an independent contractor that wants to remain with 1099s reset themselves as an LLC to operate as a business to business?
You can be a sole proprietorship with unlimited legal liability. You can be a limited liability company, an LLC with limited legal liability and a couple of other issues that I don't want to get into at this point. Or you can be a subchapter S corporation, which is a corporation that doesn't pay tax. The profit from the corporation flows through to you personally. I like LLCs and I like subchapter S's, but if you don't have significant assets, if you don't have a home or $2 million worth of art or 16 Lamborghinis in your garage, you can operate as a sole proprietor for quite a long time. The only reason we become an LLC or a sub S is to limit your legal liability. And by the way, if you have a partnership, immediately you should be either a general or limited partnership with a special writing called Partnership Agreement Act. But again, for another subject, very complex.
Okay. Errol, I'm sorry, I'm trying to go back to this. Just to kind of go back and clarify some things. If I have an employee, if I have somebody who's working for me, who I believe is an independent contractor, if I'm giving that person business cards and giving them an email address with my domain name, I've kind of just screwed myself, haven't I?
I can feel your pain from here.
Okay.
What else do? Do you let him work on your computers?
Right, exactly.
Do you tell him when to come to work?
Right, and be there at 8 a.m. Yes,
Okay,
exactly.
Read the bottom of this slide. The Internal Revenue in the state of California assume that a worker is an employee unless proven otherwise. So this is one area where you're guilty until proven innocent, and you have no due process.
So for all independent contractors, let them use their own domain name and have their own business card.
Please.
Yes. Now, a question that came up in conversation the other day. What about what's the right way to say this? The job placement agencies, right? Is that what the workaround is going to be for much of this, rather than, Errol, Gerson, hiring me as an independent contractor? Are they instead going to be going to, a Creative Circle or, any of these agencies to place me for a, 3-month position? How is that different, or how does that kind of, separate things out?
So Errol Gerson goes to Creative Circle and says, I want you to place me. They place me at the A.B.C. upside down design firm in Santa Monica. They charge a fee, 17, 18%, whatever it is. And the company pays Creative Circle, and Creative Circle pays me a certain portion. I can almost guarantee you that Creative Circle is going to have to treat me as an employee.
So that means, so some of these placement agencies may need to start offering benefits then. Is that what you're saying? Or that that challenge might be able to be made?
I believe their case is coming. I have a very dear friend who works for Sony Pictures. She is a software engineer, very highly paid, but she doesn't work for Sony. She works for the A.B.C. placement company. She gets no vacation. She gets no medical leave. She gets no medical insurance. She gets no 401k. She's not entitled to the FMLA, the Family Medical Leave Act.
Right.
And it's an outrage. Google's doing it. Facebook's doing it. They're all doing it.
Right.
And it's an outrage. And half of these workers come from India. One of these days, there's going to be a very significant lawsuit.
Wow. All right.
To me, it's morally reprehensible.
Okay. So some agencies do offer some level of benefits. It's so definitely anybody who's working through job placement agencies, pay attention to what they're doing.
Absolutely.
And I imagine that this is, really, I think what's going on here, and largely, what I'm hoping is that we've answered many questions tonight. I'm certain that there's still a ton more questions that all of us are still trying to figure out. And that, really the purpose of us doing this is to try to share more knowledge so that we can begin to better understand what we're doing, either as business owners, as employees, or as independent contractors and solopreneurs.
So Patrick, let me just summarize.
Please.
AB5 now substantially reinforces BORELLO and the ABC test. So AB5 is the law of the land in California. There will be tests.
As of January.
That's right. And Uber and Lyft are going to be front of the line in bringing a challenge. So what do you know for sure? This is going to go to the California Supreme Court. From there, may well go to 11th Circuit, may well go to the Supreme Court. What do we know for sure? It's going to be a while. Does that mean that while it's being tested, AB5 is not going to be put to test? No. There's going to be plenty audits. I'm involved in 2 as we speak. It's going to impact more employers than independent contractors, okay? So know that for sure. However, now independent contractors are aware of the law. and are now informed, at least you know. Other states are coming in fast and furious. So I'm glad that at least I've introduced you to this subject. I have no doubt that the AIGA National, through its legislative affairs vice president, will have something to say on this. I have no doubt that there are people who may disagree with my opinion, and that's perfectly fine, because at the end of the day, what really matters is what the courts are going to do when there's a challenge to AB5. And there will be challenges. There's always challenges.
Right.
If you think Uber and Lyft are going to sit back and pay another 30% for the people who drive cars for them, or Grubhub, or any of Postmates, any of those companies, forget about it. These guys have got a lot of money, and they're going to put a war chest together, and there's going to be significant challenges. However, the concept of an independent contractor graphic designer, I think, is still going to be there, whether or not the gig economy gets carved out or it doesn't. That's my opinion.
Like many laws, this is law on paper, but until it becomes case law, we're really not going to understand a lot of what's going on. I mean, just kind of a brief summary of this. Correct.
Yeah, fully agree. I mean, that's just a sample. This is a third of the stuff that I've been reading. I actually read the BORELLO case. Absolutely fascinating case.
I'm sure that you got a good night's sleep after that.
I surely did.
Just taking a look at the chat, there's a lot of conversations going on. This goes over, some people's heads just because there's a lot to take in here. Depending on our perspective, how we're coming at this, there's a lot of questions. I know that we've got some really solid business owners on the line. We have some people who are making a living as independent contractors on the line.
Patrick, may I ask a question?
Please.
Is there online with us right now a graphic design firm or even an agency that has, multiple employees, but also has independent contractors? Might I ask?
I believe that there's at least one, yes.
Okay, and without saying who they are, don't worry about it. Do they have any questions?
I've asked a couple of the questions that have come from them.
Okay.
Yep. And
my advice to this company, get an independent contractor agreement written by your lawyer yesterday. Make sure your lawyer is aware of AB5, BORELLO, Dynamics, and the A.B.C test, and incorporates into the independent contractor agreement the elements that are needed. If you do that, I think you're in good shape.
And that's awesome advice. I think every organization should have a good IC agreement. This person in particular, when they go and meet with their CPA, they're also going to be sharing back some information with us about what they learned from their conversation.
Very good.
As with everything, that we're trying to do here with AIGA Los Angeles, we just continue to try to gather more information and share it back out to our community, and help keep these conversations going forward. There are a number of questions that there's people getting amped up, saying, what can we do? How do we push back? How do we raise questions? I know that our friends up in AIGA San Francisco, I believe, are working on some letters to the government and to the legislature to try to clarify issues in regards to design and to try to continue this conversation. I want to make clear that AIGA Los Angeles is not a organization that does any manner of soliciting to the what's the word that I'm looking for? We're not trying to change legalese. We're trying to more inform of what's going on. However, there are organizations like the Creative Artists Guild, is that right? Who just pushed through the CASE Act or is working on the CASE Act at Congress. That's a group that actually does do a lot to try to affect legislation. I think, we're going to take a look and find out more about who is trying to affect legislation, and share more resources of where you can get more information for people who want to become more involved in this conversation.
And it's my opinion that AIGA National needs to take a stand on this very important subject and speak for the roughly 25,000 members.
Yes, I will support everything that you have to say there, while also saying that I can only speak for AIGA Los Angeles.
As can I.
Yes. That being said, for anybody who's on here, please know that our national organization is aware of this conversation. They are aware that we were doing this tonight. We will be sharing more information with them, and I'm certain that as this begins to spread to more states, that this conversation is going to continue to evolve and grow. With that, we're at an hour and a half. I know that there's a lot of questions that have been shared. I don't want to keep this going on too long. We are going to be sharing this recording for people to come back and look at. I want to say, please reach out to myself, Patrick at AIGA Los Angeles. For more information, hit me up online. If you can't reach me, you can reach Julie Manthe and our administration through the AIGA Los Angeles website, or you can just, bug the hell out of me and troll me all you want. I want to thank Errol Gerson for taking the time to share this information. I want to thank Amanda Hovest, our president, for pushing this forward and continuing this conversation forward, and for all the work that she and Julie Manthe did to make this happen. We did hack this together very quickly, and we hope to continue doing more things like this in the future, just to keep these conversations going. So thank you, everybody, for attending. Thank you for all of your questions. Thank you, Errol. I look forward to seeing you soon, and have good holidays.
Thank you, everybody. Nice to have met you. Good questions. I'm sure you'll have 101 more. And hopefully there will be tons more answers forthcoming.
All right. Good night, everybody.
Good night.